I think y'all are good to go.
Okay, we're streaming.
Now, members of the subcommittee are hereby advised of their duty under the State Government Ethics Act to avoid conflicts of interest and are instructed to refrain from participating in any matter coming before this subcommittee with respect to which there is a conflict of interest. Um, Obviously, we've got materials here. Hopefully, everybody's gotten them. We've already gotten some input that was also provided with the email for today's meeting. I guess, Nicole, if you want to kind of go over the inquiry and the draft, and then we can go from there if that makes sense.
Okay, that'd be fine. First, let me point out that we received this from the chair of the Grievance Committee, who expressed some concern about lawyers negotiating a non-disparagement clause in exchange for a fee refund. Because the concern is that under Rule 1.5 and 1.15, if a lawyer owes a refund, then they're professionally obligated to issue a refund without requiring any kind of benefit to the lawyer, like an agreement not to post things about the lawyer online. So this opinion covers lots of issues regarding a non-disparagement clause. First, as a condition of a fee dispute resolution, and then we'll talk about in one of the inquiries about including it in a fee agreement. So it is a condition of representation. Under the first inquiry, the lawyer there's a fee dispute that gets filed. I won't go into all like the details of the facts. You can see that for yourselves. But a client files a fee dispute, and the lawyer wants to condition a partial refund if one, under inquiry one, the client signs an agreement that releases the lawyer of all liability. So opinion number one references Rule 1.8H that requires that if a lawyer is going to negotiate a settlement of any kind of liability, like legal malpractice, then they first must give the client written notice of the ability to seek independent legal advice regarding that agreement, and then give the client the opportunity and time to determine whether or not they want to consult with a lawyer. And so, as long as Rule 1.8H is followed, then there's no problem with the lawyer negotiating a settlement of any malpractice or liability claims. It also cites RPC 84, which you remember is the ethics opinion that says that you can't negotiate the filing of a grievance with the state bar. So, as long as the settlement agreement doesn't um, prevent the client from filing a grievance or even another fee dispute, then it is fine under our rules. Inquiry number two is based on the same facts, except that this inquiry asks whether or not it is okay for the lawyer to include in a settlement agreement to resolve a fee dispute a clause that prevents the client, from posting negative online reviews or disparaging reviews about the lawyer. The opinion says no, because it is too broad. It cites Rule 8.4D, conduct prejudicial to the administration of justice, and implies that it could infringe on the client's ability to make truthful statements about the lawyer and the representation, and then also may file about filing a grievance or a fee dispute. The last part of that opinion says that if the non-disparagement clause is narrowly tailored, and does not prevent the filing of a grievance or speaking truthfully about the lawyer and the representation, does not coerce as a condition to resolve the fee dispute so that they can resolve it without this condition, and does not limit access to the fee dispute program, then a non-disparagement clause would be okay under these circumstances. The comments you'll see that we've received are mainly focused on a dislike of opinion number two. Inquiry number three includes including a non-disparagement clause in a fee contract. That is also prohibited under the opinion, and cites the Consumer Review Fairness Act, which prohibits the use of non-disparagement clauses in a form contract that would prohibit the ability to post honest reviews. So that statutory language you'll see is in the materials. And that is the basis of why it is not okay to include in a fee contract as a condition of representation a non-disparagement clause. Inquiry number 4, ask if a lawyer can condition his representation of client upon the client's execution of a representation agreement with a non-disparagement clause, and it says no, and it references number 3. And then number 5 is, may the lawyer enforce this clause? And the answer is no, because the clause is prohibited by law. It references opinion number 3. So you will see in the materials, the comments. Warren had a comment, and I'll let Warren express his concerns. Brian Ritchie also submitted a comment, and it is, and as well as Keaton Stoney, they both believe that opinion number 2 is too broad. It hamstrings or shackles the lawyer from being able to resolve a fee dispute, and mentions that these kinds of non-disparagement agreements are included in many settlement agreements, especially in other fields of practice, so not just lawyers, but in other professional fields. And therefore, the opinion is too broad. So um, that's my summary.
Fair enough. And I know Catherine Jean is with us, but I think you may have wanted to make some statements or comments, Catherine.
Yes, please.
Yes.
And I'm not very good with this technology, so I've lost the pictures. There you are. I found you again. Okay. Um, so the thing that caused the grievance chair to submit inquiry number 1 was a concern that we see all the time in the grievance process and also in the fee dispute process, where a lawyer will say, well, I'll give a refund, but in addition to resolving this fee dispute, you have to release me of liability for anything else, including malpractice, and you have to agree not to disparage me. And the concern is, if the lawyer has a complete obligation to refund an unearned fee with no strings attached, that the law, can the lawyer attach these strings and say, you have to also give me these additional benefits in exchange for me complying with my professional obligation under the rules of professional conduct to refund an unearned fee. So the concern there, I will tell you that the grievance committee already feels comfortable with the answer to the question that number 1 answers, which is, can the lawyer get a release of some kind in the fee dispute process? And the answer to that, we understand to be yes, if you give the client notice of the right to seek other counsel and the opportunity to do that and all those things. But the issue we're concerned about is the one that I don't think is actually addressed in the proposal, which is, can you get some collateral benefit in exchange for complying with your professional obligation to refund an unearned fee?
So, Catherine, I've got a question. So, does your analysis then turn on that the disputed fee is unearned, that the lawyer is professionally obligated to return it because it wasn't earned, as opposed to a dispute like I say I earned the fee, the client has some sort of complaint, and there's an issue or a disagreement as to whether it's really an unearned fee. Does your analysis change, or is it the same if it's a dispute about whether that fee was actually earned or not earned?
Well, I think it does change if there is a dispute. If the client says it's unearned and the lawyer says it is earned, the fee dispute program is not equipped to resolve those disputes. So if the parties can't agree that there's an unearned fee, then that fee dispute needs to become an impasse. And then the part of the concern is that the state bar the grievance committee is concerned about the state bar through its fee dispute program facilitating a settlement that allows the lawyer to extract additional benefits, like a malpractice release. And so it probably would be appropriate for it to be impassed and say, the state bar can't help you with this fee dispute because you can't agree that there's an unearned fee. If the lawyer is saying, I need these collateral benefits in order to be willing to give the unearned fee, give the allegedly unearned fee back, that this probably is not a suitable thing for the fee dispute program to be involved in. But I think that the answer to the question still exists, and the lawyer still has to, if the lawyer is absolutely confident that the lawyer has earned the fee, they may be willing to go ahead and do that because they feel sure that it's not a violation of the rules because it's not an unearned fee. In other words, they're paying the money to buy their peace, but they don't think they owe the money, and they think they can prove that. They, could go ahead and settle on that basis, but I don't think the fee dispute program should be involved in that process.
And then to kind of take your scenario, could that then potentially generate, because obviously you can't negotiate away, make the potential to make a claim to the state bar, right? A grievance. Then could that then ultimately end up in a grievance where the grievance committee is having to then look and determine, was this truly an unearned fee or a not unearned fee in terms of whether, so kind of like a slippery slope or a,
circular thing.
Yeah.
Yeah.
Okay.
Well, I do think that it could become a grievance. I mean, things that don't resolve in the fee dispute program almost always become grievances. That doesn't mean that the lawyer is going to be disciplined. I mean, the grievance committee is actually equipped to make a determination about whether a fee is unearned or not, where the fee dispute program is not. So it's certainly entirely possible that the grievance committee will get a grievance and will say, well, this is not an unearned fee, so we're dismissing this grievance. I mean, keeping in mind that at least 80% of grievances are dismissed because they have no merit. So the fact that a grievance is filed doesn't necessarily mean that the lawyer had some jeopardy, but it does mean the lawyer has to might have to participate in another process. I'm sorry, Warren.
Yeah, a couple things. No, is there any substantive difference between a unearned fee versus arguably excessive fee?
Well, my analysis is probably wrong, and Nicole would probably be a better person to answer this, or anybody on this committee would be a better person to answer this. But I think an unearned fee that's not refunded is by definition a clearly excessive fee.
Oh yeah, no, I agree with that. But it's like, I mean, I've literally advised dozens, if not hundreds of attorneys about getting through fee disputes with clients and what to do or not to do. And usually it's not a question of whether it was they paid money and the attorney did nothing. That's an unearned fee. But where the attorney did something, especially on a contingent fee basis, turns out that not anticipated, turns out they didn't have to do as much as they may have initially done, which is the way contingent fees work. Sometimes they go bad for the attorney, sometimes they go great for the attorney, but
right.
That's the whole, there's a lot of law behind why that's okay for attorneys to do it that way.
Right. That's not an automatic excessive fee.
I guess that's my question, where the client says it's excessive, because I think, Nicole, you and I have been talking to the same attorney recently about something like this. And just because a client says it's excessive, and maybe even because if down the road it comes to an impasse, the attorney has made an offer saying, look, I'm only going to refund if you if I get a release from you that includes any claims of legal malpractice, which I would typically advise them to try to get.
Oh, sure. Yeah.
Yeah. I mean, shit. And the client they can settle it and then turn around and file a grievance. Doesn't matter what. They can do that. But if they if they do file the grievance and the grievance committee determines that some part of that fee was actually excessive, does that necessarily mean that because the attorney made the offer to settle and tried to impose or tried to make as a condition of that settlement the release of the legal malpractice claim? I mean, is that attorney risking even making that offer, doing something unethical if ultimately the grievance committee determined that some part of that fee was excessive? I guess I'm concerned with, as long as you give the client the 1.8H advice and they decide to go through with the settlement, even with that settlement, nothing prevents them from filing a grievance, right? And then the grievance committee can deal with everything as far as the fee. But clients, unrepresented clients settle legal malpractice claims all the time, whether they're merited or not. They might agree to. And I
Right,
don't
but aren't those
see-
two different issues, Warren? I mean, one is about liability that's covered by 1.8H. And then if the client files a grievance and says, I think this lawyer collected an excessive fee or didn't earn the fee. I mean, usually they say they didn't earn it. And then the grievance committee is going to take a look at, well, did the lawyer earn the fee? Did he end representation or did the client fire
Right.
them before the matter was resolved? Then, under the rules, lawyers have an obligation to take a look at what portion of the fee that was collected or might be collected is unearned. Um,
Can I answer that? I mean, I guess my question there is, why does the grievance committee care if the client got a legal malpractice release when the pro se uh, unrepresented party was given the chance, told to get an attorney, given the chance to get the attorney, and they chose not to, and they wanted to get some money back, so they went ahead and did it. And then they turn around and file the grievance. Well, that's, people are grown-ups. I don't see how that's overreaching. I don't see how that's getting any, I don't know. I guess that's my question. And whether this body can opine on whether the lawyer is giving legal consideration for getting that release because the fee was unearned, that's kind of beyond our jurisdiction, whether it was legal consideration under contract law. I don't know. That's just, I feel like we're getting into stuff that we don't need to worry about and trying to settle cases. What?
So if this were an easy question, I probably wouldn't have asked y'all to wrestle with it. But
Yo, I know.
the concern is if the lawyer has an absolute obligation to refund an unearned fee, can they attach any conditions to doing that? And forget about the legal malpractice for a minute. The other issue about the non-disparagement. Can they say, I'm going to give you back this money. You think it's unearned. I think it's earned, but I'm going to give you back this money. But in exchange for that, I'm going to prohibit you from saying anything about me, even true things, on social media. It's not just about the money, but the issue is, can you extract a collateral benefit? And the grievance committee needs an answer to this question because it happens all the time.
So we're only talking about the non-disparagement part, or are we talking about the legal malpractice release?
I'm saying for purposes of analysis, just focus on the non-disparagement. And does that feel different to you than the malpractice release? Either one, to me, they're equivalent because they're collateral benefits that the lawyer is seeking to extract in exchange for refunding the allegedly unearned fee. I don't claim to know the answer to this question, and I understand it's very thorny. It's not as simple as it appears to be. So I'm not saying I know what the answer is. I'm just saying I know what the question is, and I see it almost daily. So we really need some guidance about that. And I think the lawyers of North Carolina need some guidance about that too. And it
So,
puts the fee dispute committee in a program in a very awkward spot because they've got these people who seem to be willing to settle on this basis, but there's this nagging feeling that the state bar is facilitating something that might be a rule violation, which they don't want to be in that position.
Bill, it looked like you had something to say.
I did, and one thing that Catherine said that sort of is consistent with what I was thinking before we started this meeting is the idea of a collateral benefit. There's a question to me, you're negotiating terms with, is this a current client? Is this a former client? Is there a difference? Let's say it's a former client, they've terminated services. But what you're negotiating here is strictly a financial issue. Do I owe you money back? That's a very narrow question. You look at your fee agreement and all the things we typically look at. But to then condition a collateral benefit flowing to the lawyer on the settlement of that issue causes me problems. Whether it's a small thing like don't post crappy reviews about me online, or a big thing, which is don't file a malpractice claim. What if, I'm sitting here and this comes up and I tried an equitable distribution claim and went to trial, and the client lost on a major issue, and I become aware that they lost on a major issue because there was a piece of evidence that I didn't acquire that would have gotten a different result. Okay. I know that. Client doesn't know that. And so, is it fair for me to say, well, okay, look, all right, I'll give you back $1,000 if you'll release me from malpractice claims. I know, Warren, I understand you want those releases to be upheld, but there are circumstances where it's simply unfair for those, from a consideration standpoint, to be negotiated between the lawyer. Lawyers in a superior position. So when we start looking at collateral conditions and benefits flowing to the lawyer, apart from the narrow issue between he and the client or she and the client, that causes me problems. And I don't know how I make a distinction between a big collateral thing and a small collateral thing. I'm less worried about, saying you can't post crappy reviews. None of us like that. The good thing about being my age and getting ready to retire is I don't really care. I haven't looked at my reviews, and I don't frankly care what they say. And they don't seem to affect my business in any way. So I'm happy. But I know for not everybody's in that position, and for somebody that's earlier in their career, that is those reviews are very important. That's a much bigger issue, and I'm kind of in favor of lawyers being able to somehow control that, or to avoid those sorts of reviews. But I don't know that I don't feel that it's appropriate as a part of a fee dispute issue for me to attach any collateral consideration. It's like being a mediator and you're negotiating this issue and both parties disagree about their positions, but you bridge the gap by saying, well, let's throw in this second issue or this second and third issue. So it becomes, I'll do this on this issue if you do that on that issue, and then we settle this primary issue. And I think once we do that, if we're dealing with our clients, that just does not feel right to me. Looking at it from a public standpoint, I think it's hard to justify that. That's my feel about it. So I think it's what Catherine was saying about collateral issues. I think that, to me, that's sort of the key here that might lead us to a consistent response.
Can I want to kind of test for consensus here. I think we were kind of the way that the conversation was going. It sounds like if the issue we're focusing on is, can a lawyer attach this type of additional interest, whether it's the non-disparagement or what have you, but when we're in this situation that a lawyer has an obligation to do something, the fee is unearned, the fee is clearly excessive, whatever, there's some sort of funds that need to be returned. And I guess that's something, who makes that determination is that can get into a lot of sticky parts there. But I think when we have that situation where a lawyer has, they're supposed to return unearned fees and they're just not doing it, they're holding on to it. Maybe they're holding, they got, I don't know what you want to say. They had $10,000 deposited in the trust account. They only used $5. They're supposed to return $5, but they're holding it. And they say, well, listen, I'll return it to you as long as you don't write anything negative about me. I imagine we all agree.
That's
No, you have an
unethical.
obligation under the rules to return that. You can't tack on. And so I think in this scenario with the fee dispute, it's tougher to figure out when are we all on the same page that the lawyer owes a refund. And I think maybe that's what I'm hearing as kind of the really gray area, because if lawyer says, I earned that fee, and client says, no, you didn't. And lawyer says, okay, listen, I disagree with you, but I will refund a fee. I'll refund some portion in exchange for this. I guess maybe that's my question. Do you all see the lawyer as essentially giving up or conceding the point that there's a refund even owed in exchange for this non-disparagement or malpractice release? Is that the sort of thing that that we think is permissible under the rules if there's truly an impasse, there's a disagreement as to whether or not the fee is owed? I think in the fee dispute process, if there's a fee dispute, maybe this is a question that we would have to figure out as well. If the fee dispute process produces a result with one of our bar mediators saying, yeah, I think I looked at everything, I think you owe $500. At that point, is that something that the lawyer cannot tack on? Because a bar official has said, you owe this under the rules, you do owe a refund, and that's when you can't tack on. It's only, I feel like maybe I'm wondering, would we agree if the fee dispute mediator says you owe a refund, then lawyer cannot tack on? Is that, maybe let's start there.
Yeah, I think you're hitting the nail on the head, Brian. I think there's a distinction. It's the gray area that I'm more concerned with. I think if clearly you didn't do the work and you're holding funds that belong to the client and you're holding it to hostage basically to get some other waivers, to me, that's a no-brainer. That's not the situation that causes me concern. But as a family law practitioner, what causes me concern is the majority of the fee disputes are not whether or not the lawyer did the work. It's the client's not satisfied with what the results were, so they do a fee dispute, and the lawyer goes into the fee dispute and was like, look, to avoid problems in the future, even though I know I earned this fee, that the work was done, I'm entitled to the fee, but I'm willing to return the fee in exchange for something else. That, to me, and again, I haven't ever had a fee dispute, so I don't know, but I'd be interested in any on the fee dispute, committee, whether that's the more common scenario, because my impression, at least from the family law perspective, is that is. And if that's the case, would a blanket rule that says you can't get any additional kind of waiver, would that chill the willingness of a lawyer then to say, well, I earned that fee, but I'm willing to resolve this issue by returning a certain amount, because they are getting something. And maybe that's to Catherine Jean's point. Well, then maybe that's not really something that should be being addressed by the fee dispute committee. But my impression is that that's a common scenario for a dispute.
It is a common scenario, and that's why we're here, because we keep seeing this. And Brian and I talked about this a few weeks ago, and we talked about the fact that if one party contends it's unearned and the other party contends it's earned, and the lawyer doesn't want to make a refund without getting some kind of a release, then that's probably just going to kick it out of the fee dispute program and result in an impasse, which is fine. I mean, I don't think that should be a problem.
Is the
and
concern?
Then somebody else decides whether this is an earned or unearned fee. not
Is the
dispute
concern of
facilitator
the,
will never make that determination. I'm sorry.
right, is the concern of the grievance chair that the fact that these things have to go through the fee dispute program? I mean, lawyers and client, I mean, I guess, so here, and what Nancy described down there is about 90% of the fee dispute issues that I talk to clients about, to attorneys about, where the client is saying you didn't do something right. Oftentimes, and I mean oftentimes, are doing that merely as a means to try to chisel the attorney's fee down. And it is BS. It will get nowhere with the grievance committee if it gets there. But by telling the attorney that he can't, if he returns anything to them, that they can still turn around and sue him for malpractice, he's not only given up some leverage that he has in a dispute that is largely a BS in many of those cases. He's not only given leverage, he's also given up a defense if he gives any money back, because it would be a literal defense in the case to be able to retain either the money or to collect a fee that is still owed. So I guess I have a real problem with telling attorneys that when they have fee disputes with their client, where the client's been told they can talk to another attorney about whether to do this, that they should be treated any differently than anybody else. I will say, if they're, well, no, I mean, they've been given all the 1.8H protections on whether to get somebody to do it. I think that this concern about the times where it's clear that it's an ethical violation, and the attorney, like a client comes and says, "Give me my file," and the attorney says, "No, I'm not going to give you your file until you sign this release." Well, that's ludicrous, right? We all know that's unethical. That's the same thing as you were saying, where it's money that's clearly unearned. That's going to be unethical. But to do that, but that is not 90% of these fee disputes, and hell, maybe even more. And in those cases, the parties ought to be able to negotiate. I mean, the way we're heading here, I'm almost where an attorney would be dumb to agree to give any money back in the fee dispute settlement program, and just wait and then make the client sue them in order to get anything back. I don't know. I don't see why it's a huge problem to be able to couple a legal malpractice release with a fee dispute resolution.
Well, I guess maybe that's the thing. I don't know if we are. I don't know if there's. Well, I don't know if there's disagreement that that thing can be done when there's a dispute. If there is a true dispute, lawyer says it's earned, client says it's unearned. We're basically at an impasse, and in that scenario, now I think that's where we're even taking the fee dispute process out. Let's just say lawyer and client are interacting, and they're having this back and forth, and lawyer says, "Listen, I just want you to go away. Completely disagree with you, but I'm willing to refund X if you provide this release." I think the rule that we're kind of focusing on is if lawyer has an obligation to refund, they can't tack on. That's what I'm kind of hearing some thoughts there. Now, whether that obligation is triggered, I think is dependent upon whether it's going to be that question of, is there an unearned fee, whether there's entrusted funds that have not been returned. I mean, it's similar to the file being held hostage. When you get into the valuation, of fees, that's where, of course, it gets super murky. But I think that would be one of those things where if a lawyer, let's say a lawyer actually did, said, hey, I disagree with you completely. I don't owe you any refund. And client just insists on it. Lawyer tries to say, listen, I'll give you some sort of refund in exchange for like a malpractice release or a non-disparagement clause or what have you. And client says no. And in fact, I can't believe you actually offered that. I'm going to file a grievance against you. I think depending on the circumstances, the grievance committee might find that, this lawyer's position that they earned every bit of the fee. They earned all 30 grand of their flat fee when the matter was resolved and the client said, hey, I actually don't need your services the next day. Something, let's just kind of make it a little ridiculous sort of thing. There's some sort of refund. We would say holding that would be clearly excessive. I think the grievance committee in that scenario could say, not only did you collect a clearly excessive fee, but you tried to extract this additional sort of consideration when you had an obligation, and you should have known, lawyer, that you had charged a clearly excessive fee, you owed a refund, and you were refusing to pay that back. It's easier to see in that very clear situation. I think what I'm saying is, in the moment when there's an impasse, when there's a disagreement, it may not be obvious that tacking on is or is not impermissible. I think I'm hearing the committee say it would be impermissible for a lawyer to refuse to comply with their professional obligation in exchange for or conditioned upon somebody giving them something extra. If it's your obligation, it's your obligation, period.
That's another question. That's not what we're asking here.
Yeah, and I think that's the question then of, well, what is the professional obligation? And that's going to be something that I think would have to be determined, whether it's determined by a court, determined by the grievance committee or whatever, but it's going to be an after the fact sort of thing. Yeah. But lawyers could be, I think, maybe need to be aware that, yeah, if you ask for a release and that your position is completely unreasonable and you're actually thwarting your own or just ignoring your professional responsibility to refund, then you might be committing yet another rule violation.
That's kind of like
the opinion could say, if that's what we want, if that's what the committee is thinking. I don't know. I'm trying to flesh out just what the rule or the standard that the committee seems to. I feel like the committee's floating around the similar sort of mindset.
Yeah, to me, Brian, it's if your analysis of the ethical rules obligation, you have an obligation to return the fee. Like you said, you can't hold it hostage for collateral benefits. But if there's a dispute, whether it's that gray area, where the lawyer says, no, I earned that fee, I'm entitled to it. And the client says, well, you didn't do a good job and I want to have that, I'm disputing that fee. Then to me, that's a different situation. So if there's a way for us to sort of parse out in the opinion so that it doesn't necessarily come across as just a blanket prohibition.
That's what I'm concerned about.
To me, that would be more in line what I hear the direction I hear the discussion here going in.
Can I ask Catherine, can I ask a question as far as the scenario that y'all have seen, is it fair to say that when there's an impasse, no agreement and all that stuff, and there's like, well, I guess maybe let me just stop there. When there's an impasse, the fee dispute folks just say, all right, there's an impasse. You say it's earned, you say it's unearned, or it's not enough, it's too much, whatever it is, but there's an impasse, so we can't resolve this. And there's no sort of extra, lawyer says, well, hey, listen, I'm willing to give this money back in exchange for this release. I don't know if the fee dispute process is actually, I guess, facilitating the back and forth, the transmission of those terms. And is that what's causing the problem, or is it the situation where through the fee dispute process, it's pretty damn clear that lawyer owes money there's a refund owed. And lawyer saying, yeah, you say there's a refund owed, but I'm only going to do that if I get this release. Like, to me, that's a different scenario where there's the, I guess the fee dispute process has determined, lawyer, you owe some money back. There is a refund for whatever the circumstances are. Is that the scenario that you're dealing with?
Well, we're dealing with both scenarios. I mean,
Okay.
sometimes it is obvious, but again, the fee dispute facilitator is never going to declare that you owe a refund.
Okay.
They don't do
Yeah,
that.
no.
They do not do that. They only say the parties have, here are some questions you need to consider in deciding whether you're willing to resolve this thing. But the fee dispute facilitator doesn't render an opinion. Sometimes it's obvious to the fee dispute facilitator that a fee should be refunded.
Yeah.
Sometimes it's obvious that it shouldn't be refunded. It just varies. My thought about this is, I guess, possibly an opinion that says, if you do owe a refund of an unearned fee, then you cannot extract collateral issues. And then that's for the lawyer to decide, like so many other ethics opinions say, this is, these are the things you need to take into consideration. Here's what your professional responsibility is. You need to apply this to your facts and make a determination about what you need to do in your individual case.
Yeah, I like that. In fact, it reminds me of how we deal with the quote non-refundable fee.
Yes.
There's no such thing as a non-refundable fee. And then when you talk about, is a fee clearly excessive? Well, guess what? You really have to look at it in 2020 hindsight, right? So that's why we say no lawyer should ever be able to say that a fee is non-refundable. It's only earned upon receipt, but then you're going to still have to look at it in retrospect and yada, yada, yada. And if part of it is clearly excessive, then you got to give that back. But that's a whole different calculus than what we're saying here, where you're saying on the front end, you can't settle a damn fee dispute without where you, I mean, in any, it's in essence a contract dispute or a business dispute between two parties. And any one of those times, those two parties, if they reach a settlement, or if you're going to be paying out money, you're going to want not just a release of that one thing, you want to release every dispute you might have with the other party, if you can get it. And that's why you get two attorneys involved a lot of times, or they just agree to it. But that's how people resolve business disputes all the time. They don't leave other things hanging out there if they can avoid it, so that they can then turn around and get sued again. So that I guess that's my real concern here, is that we're making lawyers vulnerable to double dipping by the client.
Yeah, and I think that's where the opinion could clarify that the I guess the prohibition that we're talking about really only applies to where the lawyer has an obligation, and that is a consideration of their obligation under the rules of professional conduct. It's going to be something that they have to look at in the time. It also is something that they could get tagged for if they're looking at themselves incredibly favorably, but the rest of the profession would say, and represented by the grievance committee would say, no, you absolutely did not earn that fee. That was a clearly excessive fee. And so I think where maybe that would be a thing that the opinion to the, I don't know, I'm trying to think of the wording here for the opinion to clarify, when you have the true impasse, the true disagreement, where a lawyer is very reasonably insisting that they earned the entire fee paid, and the client is saying, no, I'm owed some sort of refund. And we're talking about that, like this is a coin flip situation. Just to resolve the issue, I'm not hearing the subcommittee say that anybody has a problem with that scenario, permitting the lawyer to say, listen, I'll just settle this, but I want to get the release or the non-disparagement. Because in that scenario, the lawyer is not clearly obligated under the rules to actually refund. The problem that we're trying to address is where lawyer is obligated to refund, and they try to tack on some sort of collateral interest. Is that where we're at?
That raises
Yeah,
again, a problem for me, because I know when lawyers that all in our districts, we talk to our lawyers, they read these because they want instructions
Yes.
about what they can and can't do, right? They need guidance. I had the privilege of being on the grievance committee back in like 1997, 8 and 9. And I never saw a fee dispute come through where the lawyer believed that he or she clearly owed a refund. And a couple of those went to the DHC for trials. And in one case, the lawyer won. It was a lawyer from Charlotte, Deal, and he had a huge, non-refundable retainer. And I remember speaking up at that time saying, look, when you hire that son of a bitch, you're paying a lot of money and you know what you're paying for. All right. You're paying for nasty, big time representation. There's a price to that. So people go in with their eyes open. But anyway, he of course clearly thought that he earned the fee. And I think, as I recall, he refunded the fee, but said, no, I still want to go to DHC about this to make a point. So when these things come up, lawyers who are in this position are never going to be saying, well, I know up front that this is clearly excessive, or I know. They're going to always believe to their core that they don't owe this money back. So anytime they're negotiating a true dispute, and they're attempting, and I'm with Warren, I wish we could do this for a lot of reasons, but they're still negotiating a benefit on a collateral issue. So I'm the keep it simple, stupid rule guy around here. But to me, keeping it narrow is more helpful to the lawyers in reading what we can and can't do. And I just think it's an issue. If it's a fee dispute, it's a fee dispute. You owe the money or you don't owe the money. If you settle it, you settle a fee dispute, but you're not settling other issues. That goes beyond, in my opinion, where we ought to be. That's just my feeling.
I guess my question there is, in just about half of the legal malpractice claims I get, part of the claim is a return for fees, a return of fees. I mean, does that mean that our lawyer can't settle everything together? He's got to have a settlement of the fee dispute and then leave himself open. I just don't think that's doable, number one, and I don't think that would be required by our courts. And I think we're getting out of our lane here when we're saying an attorney can't settle a claim that anybody else in the whole world can
Well,
settle.
in that case, there is a claim. And so in the scenario I'm reading, there's not a malpractice claim. There's a fee dispute only.
Just a fee dispute.
At that point. Yeah, at that point.
But we're talking about fee disputes, not just in the formal fee dispute process, but when a client is, saying like, hey, you didn't work hard enough for me, even though you put in the time and you billed the hours. I don't like the result that you got in court. And an attorney's willingness to say, well, look, I'll refund X amount to keep the client happy, right? I mean, I don't know. My impression is that's the majority of the scenario. And then I would feel maybe differently about my willingness to do that if I'm not getting something, because I'm refunding something that I'm entitled to, right? Like I actually earned it. But I think, going to your point, like I would be very comfortable if it's narrowly drawn, right? Like if to Brian's point, if it says, you as the attorney have to look at what's the nature of the dispute, and what are the ethical rules about an excessive fee or an earned or unearned fee, and in those instances, if you have an ethical duty to return that, you can't attach anything to it. So to me, the answer is more a qualified answer, or like maybe it depends on the circumstances, which, that's what we like as attorneys anyways, those, not so black and white answers.
Right.
Agreeing with Nancy on that. And what about, so the only fee dispute I've had is where a client didn't pay my bill, and I sent them a letter saying that, before you sue them, you have to send a letter. And then they responded, and the fee dispute committee said that there was no cause. I had done the work, obviously, and it was a crazy situation. So, what if in that case I was paid? It was a weird situation, but what if we had negotiated and I agreed to half my, instead of pursue the whole thing, and then part of that there was a non-disparity clause that I negotiated. Right? That's different than there's money in my trust account. I'm being I'm being the plan. So that's just to add a little, but I agree with Nancy Grace that if you negotiate something with your client, whether there's a fee dispute or not, can be narrow and tailor something that fits what Bill's talking about and what Warren's talking about that would be powerful.
Stacy, I'll admit, I had a hard time hearing you with your microphone was kind of cutting in and out, or sound like you're in. What's that?
Is this
No.
It's still doing the same thing.
Huh. Okay, well, I've been having issues. That's why my internet went out. So I don't know.
Oh, no.
Okay.
Well, we're just going to imagine that you said something just incredibly prolific, as you typically do. But yes, I don't know how to incorporate this. I want to recognize we are at 1:54. I have a hard stop at 2, but it sounds like this is, I don't know, Nicole, what do you think?
Yeah, so I think
It's going to require another subcommittee meeting.
Yeah.
And maybe we can try to get it in before the October meeting. That's going to be really tight. But I think what I'm hearing is that I'm going to make changes to opinion number 1, maybe opinion number 2, that puts the burden on the lawyer to determine that whether or not they owe a refund. And if so, they cannot tack on. If they determine that they do not owe a refund, then they can tack on. Is that right? Okay, so I will
Sort of,
do
right.
some wordsmithing with opinions number 1 and 2. We haven't even talked about the other opinions. So I think we're going to need another subcommittee, Kevin, to
Are
discuss
you
those
talking about
others.
3 through 5? I feel like we can do those pretty quickly.
Does anybody have any objections to 3 through 5?
I was going to say, no way you can put that in your damn engagement agreement.
We all agree on that.
Yeah.
Okay,
All right.
so it's just 1 and 2 that we're focusing on.
All right, we'll just see you in October then.
I
Okay.
mean, we can still talk about those. Don't get me wrong, but those were easy ones. It's just 1 and 2.
Okay, well then, I will work on 1 and 2, and then we'll keep this in subcommittee, make that recommendation to the full committee, and then after the October meeting, we will meet again to discuss the changes to.
Yeah, and Nicole, if I can, I think, and Bill, correct me if I'm wrong, I think one of the things that you were still struggling with is when you're talking about, like, should a fee dispute purely be a fee dispute without ever being able to tack anything on, plain and simple. And so I think that's something that was what I understood your position to be. And I know, Warren, you feel like there's, I guess, with the situations you've dealt with, there's kind of more, it's fee dispute plus, right?
Almost always fee dispute plus.
Yeah. Yes. And
They're using the plus to argue the fee, and then and they really want, all they want is a lower fee.
And so maybe there's still a question to consider of, is there something when the sole issue is the fee dispute, should a lawyer be limited to only resolving the fee dispute and not having other things on, as opposed to fee dispute plus? That's the technical term. I would like to get the subcommittee's impressions of that notion nailed down as well. Like, I think, Nicole, what you were describing is kind of what I was thinking the subcommittee's talking about, but I think there is maybe that question that's pending out there about exclusively fee dispute being the basis for the I guess the disagreement. Should there be some sort of requirement that lawyers just, if it's only fee dispute, you just deal with the fee dispute and that's it, not getting anything else. But let's talk about that later.
Sounds good. Thank you. Can you hear me now?
Yep. Now we can
Yeah,
hear you.
sounds
Oh,
great.
okay. I changed my speaker input, so I'm not going to say what I said before, but
Okay.
basically I said whatever Bill and Warren said is great. Let's limit it. And
You also agreed with Nancy.
I'm sorry. Yes. And Nancy Grace. I really thought she encapsulated it, but I'll tell my horror story next time.
Okay.
Stacey just agrees with everybody. So agreeable.
That's right. Okay. Thank you guys.
All right.
Well,
Thanks,
thank
y'all.
you all. I'm sorry to be so tiresome.
No.
Trying to make life
no.
hard.
Catherine, we
No,
love you.
that was very helpful to,
Welcome to the ethics committee, Catherine.
Yeah. Yeah, I know it's not easy. That's why they wouldn't ever have assigned me to this committee. They'd say, she's like, no, this is the answer, and sometimes it's not that clear, and I get it. But thank you all very much for letting me participate.
Thanks.
Absolutely.
We'll see y'all next time.
Thanks.
Bye.
Bye.
Okay,
Everybody
thank
take
you,
care.
everybody.